This is English shorthand dictation number 333 and the dictation speed is 120 words per minute. Ready? Start. In Indian courts, affidavits are used extensively for presenting evidence and other information during civil and criminal proceedings. Under the Code of Civil Procedure, the court may order any fact to be proved by an affidavit. In a civil case, the examination in chief of a witness is always in the form of an affidavit. Apart from the main evidence, affidavits are required to be filed for various other purposes in the court. Every plaint or pleading is to be supported by an affidavit for proving the facts contained therein. Interrogatories are also to be answered by an affidavit. The court may also order the production of any relevant document on oath by a party in possession of such document. In case of failure of service of summons, the officer responsible for the service has to give his report supported by an affidavit. In the criminal proceedings, an application for plea bargaining has to be accompanied by an affidavit of the accused stating that he had voluntarily preferred plea bargaining. In brief, every assertion of facts in the court has to be supported by an affidavit of the party in the knowledge of those facts. The court relies on the facts only if these are either stated in the oral evidence on oath or by written submission supported by an affidavit. An affidavit is a written statement made on oath or affirmation before a notary or other empowered person to be used as a substitute for oral testimony. An oath is a promise to speak the truth with God as a witness under the belief that he will punish the person for breaking this promise. The justification of taking oral and written testimony on oath in courts is based on the belief in the theory of divine punishment in case of a false statement. The practice of submitting a written statement in courts on an affidavit is prevalent in most of the countries which were part of the British Empire in medieval times. However, many such countries have curtailed its use by modifying their procedures to suit present day requirements. Most recently, in August 2020, Ireland has replaced affidavits with the statement of truth in the civil proceedings as a measure to combat the COVID 19 pandemic. This statement of truth is not required to be made on oath or affirmation and can be transmitted electronically to the court with the digital signature of the deponent. Under the federal law in the United States since 1976, an unsworn declaration can be used in court proceedings in place of a sworn affidavit. In 2016, the Uniform Law Commission of the United States has drafted a Uniform Unsworn Declaration Act to be enacted by every state there. In the United Kingdom, affidavit in civil proceedings has been replaced with a statement of truth with the introduction of Civil Procedure Rules 1998. There is an earnest need to modify procedures in India also to minimize the use of affidavits in courts. It needs to be examined whether a written statement on oath or affirmation is in any way more effective than an ordinary signed statement in discovering the truth, which is the ultimate aim of a court. Traditionally, a statement on the affidavit is considered more efficacious in bringing out the truth because an oath or affirmation is supposed to have a moral force on the deponent. However, doubts have always been raised on the efficacy of oath and affirmation in discovering the truth in courts. Jeremy Bentham, a renowned jurist, political reformer, and philosopher, described all oaths as useless. An affirmation is a counterpart of the oath which was devised in the 17th century to accommodate the separatists who refused to be sworn because the act of swearing was blasphemous according to their beliefs. It is a formal declaration without direct reference to divine authority that the witness recognizes and will uphold his full obligation to tell the truth. In England and other common law countries, affirmation is allowed only in exceptional cases on the specific request of a witness because of his religious beliefs. However, in India, anyone can opt to give oral testimony or an affidavit on affirmation instead of making an oath, as affirmation has no connection with religion and God. It is likely to have much lesser moral force than that of an oath on a person to speak the truth. Once an affidavit is allowed to be made on affirmation, the rationale behind the sworn statement is substantially lost. There is little difference in the moral force of an affidavit on affirmation and an ordinary self declaration. In the modern world, a stringent law to punish a false statement is more effective in bringing out the truth in a court. In most common law countries, an offense of giving false evidence called perjury can be invoked only when false evidence is given on oath or affirmation. Therefore, an oath or affirmation is required not only for applying moral force on a deponent but also for making him liable for the crime of perjury. Because of this definition of the crime of perjury, the countries which replaced affidavits had to make new provisions in the law to punish a person for giving an unsworn false declaration in the court. The law in India is more pragmatic in this regard. Under the Oaths Act 1969, every person giving evidence on any subject before any court is bound to state the truth on such subject. An oath is not a condition precedent to the obligation to state truth under Indian law, as is the case in most other countries following common law. Under Section 191 of the Indian Penal Code, whoever, being legally bound by an oath or by express provision of law to state the truth, makes a false statement, is said to give false evidence and is punishable under Section 193. As every person is bound to state truth by Section 14 of the Oaths Act, filing a false, unsworn written statement in a court would constitute the same offense as the filing of a false affidavit. Therefore, even if the affidavit is replaced with a simple self declaration, it will not dilute the punishment for giving a false statement in court. Now the time has come to remove the requirement of sworn affidavits in the court proceedings. In the place of the affidavit, the deponent should be required to file a signed declaration that the contents of his statement are true and he understands the legal consequences of giving a false statement. Such a statement may be called statement of truth or unsworn declaration or anything else. The E Committee of the Supreme Court, set up to increase the efficiency of the Indian judiciary by using modern technology, has also emphasized the urgent need for re engineering judicial processes to utilize the full potential of the technology.